All I'm
Okay,
doing is asserting my right
all
to
right.
represent
It's
myself.
referred for competency. We'll prepare an order so she can be evaluated so we can
Well, I
determine.
object to that. I
You
object
can
to the
object to
competency
whatever you
evaluation.
want to object to, but if you don't participate, then I'll put you in custody until we get an exam done. Do you
But why?
understand?
But you have to say that there has to be a reason, there has to be a cause for it, and I have a right to know why you are.
This case is already packed with tension before we even dive in. On one side, we've got Lindsay Janeski, a defendant who insists on asserting her rights, challenging jurisdiction, and even trying to represent herself despite already having an attorney. On the other, the state of Michigan, determined to move forward on charges of assaulting, resisting, or obstructing a police officer. What's fascinating here is the immediate clash between courtroom procedure and a defendant who refuses to play by the rules. Will her insistence on doing things her way help her case, or land her in deeper trouble? Keep watching because this hearing takes a sharp turn.
All right, the court will call the case of the state of Michigan versus Lindsay Dineski, case number 24S00096.
Tiffany Woods for the people. Allison Muller here on behalf of Lindsay Duneski. Ms. Duneski, can you state your name, please?
Yeah, sorry, I was just trying to unmute. Lindsay Dineski?
Thank you. All right, we're here for a pretrial today, and are you in possession of all of the documents that your client has filed?
I am, Your Honor.
Okay, can we see counsel in the breakout room? We're back on the record in the case of the state of Michigan versus Lindsay Dineski. You don't need to place your appearances back on. We had a brief discussion regarding all of the filings that were filed, although the defendant has an attorney in this particular case. So at this point in time, we need to make a record of what's going on in this matter, and we can go from there. Ms. Moeller, it looks like your client submitted 4 different filings. First of all, the court has no requirement because we're not a email e-filing court to accept email pleadings. We did do so. Your client was advised that there is a page limit to how much we'll accept for any one hearing. So that happened, and you should be aware that that did happen as well, and that she will need to follow any filing requirements in the future. And I believe that she represented to staff that she had filed those with the prosecutor's office. Ms. Woods is indicating she did not receive them. I don't know whether they were filed with the prosecutor's office or not. Having said that, do you have a copy of the filings that your client filed with the court?
I do, Your Honor. I received those. Those filings were sent to the court, and just now, realizing they were not sent to prosecution, I have forwarded those to Ms. Woods.
This is where the drama starts to heat up. Lindsay claims she followed instructions, but the filings went to the wrong prosecutor. From her perspective, she did everything right. Notice to the main prosecutor should have been enough. But in legal terms, filings must follow very specific procedures. Courts don't just care that you tried, they care that it's done by the book. This moment shows the gap between what defendants think is fair and how rigid courtroom procedure actually is. Question for you all: should courts give more leeway when someone makes an honest mistake, or is strict compliance the only way to keep order?
Thank you.
I sent them to the other prosecutor. I apologize. Her name was Ellie, I think, because that was the one who it said she was the prosecutor for the county. So I just probably sent it to the wrong prosecutor.
So it is a he. That is
She,
the
okay.
chief prosecutor, Ellie Savitt, um, and they probably did not get sent to the proper place because of the way you filed them.
I filed them the way I was instructed to file them. I called and asked for instructions, and I did what I was told. So I didn't. I was told that the filing requirements were to email them, and that's what I did. So, and then I was notified after the fact that there was a limit. They made an exception because they didn't notify me. And then I told them I emailed the prosecutor, verified the email, and so as far as I know, the chief prosecutor got them. I just didn't know that I was supposed to send them to the other prosecutor too. I thought, notice to agent and notice to principal. So I thought if I sent them to the main prosecutor, any of the assistant prosecutors would get them. Because I didn't know which one would be on the case today.
Miss Woods?
Yes, Judge. I mean, I'm just opening up one of the one of the files now. I mean, I would need time to review all of this. I would not be able to. Yeah, I would need time to review all of these, Judge.
Thank you. All right, so first of all, Ms. Janeski has counsel, so whether or not she should or has the ability to file filings in the first place is something I'm still mulling over because she has counsel. So any pleadings should come through her counsel. And
Yeah, they
then,
refused to file it, so.
ma'am, I didn't
Oh,
say
I'm
it.
sorry. I apologize.
And then, secondly, these are not proper pleadings. They're not filed in the proper format. They're not filed with the proper spacing. They're not filed according to any of the court rules. So
They
that's
don't
the,
have to be though,
ma'am,
which I put
they
on
do.
there.
Ma'am, if you speak up one more time, you're going to be held in contempt of court.
But I thought this was my hearing. I
Ma'am,
should be able to
ma'am,
speak on my
all
own
right.
behalf.
You're not able to speak on your own behalf unless you don't have counsel, and you need to stop talking. One more talking, it's going to find you in contempt of court, and I'm going to give you 15 days. So please stop talking.
Now here's the courtroom pressure cooker. Lindsay interrupts the judge, insisting she should be allowed to speak because it's her hearing. But in reality, when you have legal counsel, the court expects your attorney, not you, to argue on your behalf. By pushing back, she risks being held in contempt and even jailed. This is a prime example of a defendant clashing with courtroom authority. The judge is patient up to a point, but every interruption chips away at Lindsay's credibility. Do you think the judge is being too harsh here, or is he justified in trying to maintain control?
Ms. Woods is indicating that she needs time to look at those pleadings and to be able to respond. Ms. Moeller, what is your position? I haven't heard anything from you today because she actually has.
Thank you, Your Honor. Ms. Janeski and I did, prior to the last pretrial, discuss. I didn't know exactly what she was going to be filing, but I did understand the basis of her legal argument. Her and I had a conversation where I didn't agree with the grounds for filing. It is correct that I said I would not be filing this on her behalf because I found the legal argument not to be correct. At this hearing, then Ms. Janeski did file these motions, and so I would discuss it further with my management, but I would not be proceeding with these arguments at a hearing if the court were to set it for that. I understand Ms. Janeski does want to proceed with these arguments, and I believe that she's requesting to represent herself if this court sets this for a motion hearing.
Now, Ms. Janeski, are you requesting to represent yourself?
Well, I'm asserting my right to represent myself. I'm not requesting.
All right, then if you're not requesting to represent yourself, then what's going to happen is you're going to continue to have counsel.
Well, I'm asserting my right, which is much stronger than requesting. I shouldn't have to request something that I have a right to. It just should be automatic, right?
All right.
Like the Sixth Amendment
It is not,
and the Constitution.
it is, ma'am,
Yes.
it is not automatic. So first of
The
all,
Sixth
ma'am,
Amendment says,
stop
right?
talking.
Well, you asked me a question. I'm answering under
No,
the Sixth
I heard
Amendment.
you. No, stop talking. So look, this is the way it's going to work. I'm going to give you what your rights are. And then if you make a choice to represent yourself, you can, after I've finished giving you those rights. Do you understand that part?
I comprehend it.
Okay.
Yes, ma'am.
So, first of all, what you're charged with is police officer assaulting, resisting, obstructing. It's an attempt. It has a maximum penalty of up to 1 year in the Washtenaw County Jail. Do you understand that part?
I comprehend that that's what you're charging with. I don't understand it because it's false.
Okay. Do you understand that that is what the maximum penalty is?
I do, which is why this is unconstitutional, because I was the victim in the case and
All
falsely
right, I
arrested.
think what I'm going to do is refer her to make sure she's competent, because at this point in time, if she can't understand and she wants to use a different word, then I guess what I need to do is figure out what.
Comprehend means that I know
Yeah.
what it means. Okay. Understand means that I'm understanding the court, and I am not understanding the court because I'm challenging jurisdiction. I don't need a competency evaluation. I see a psychiatrist every month because I have ADD. So if you would like me to present to you that I'm mentally fit, that's fine. But for you to say that I have to have a competency evaluation with no cause because I'm asserting my
There's
rights, that's a
plenty of-
violation of Shearer
there-
versus Cullen. All I'm
Okay.
doing is asserting my right to
Alright.
represent
When
myself.
it's referred for competency, we'll prepare an order so she can be evaluated so we can
Well, I
determine.
object to that. I
You
object
can
to the
object to
competency
whatever you
evaluation.
want to object to, but if you don't participate, then I'll put you in custody until we get an exam done. Do you
But why?
understand?
But you have to say that there has to be a reason, there has to be a cause for it, and I have a right to know why you are.
This is the turning point. The judge questions Lindsay's understanding, pointing out her unusual responses about comprehend versus understand, and immediately moves toward ordering a competency evaluation. Competency hearings are serious. If a defendant can't understand the charges or assist in their defense, the case can't proceed normally. Lindsay insists she's mentally fit, citing monthly psychiatric care for ADD, but her behavior raises red flags for the court. Here's the tension. Is she cleverly asserting her rights, or genuinely unable to follow courtroom procedure? The stakes just got much higher, because a competency ruling could completely reshape this case.
Forcing me to do something that I don't want to do when I thought I had a presumption of innocence. I thought I'm supposed to
I'm
not have my
referring
rights.
for competency. You need to stop talking. And if you don't participate, I'm going to put you in custody. And I already placed on the record why.
Okay, and also, isn't the officer supposed to be here today to testify? And if
No,
he's not,
that is not
Well-
how that works. See, you don't
I
know
thought-
anything about this, and that's why you shouldn't be representing yourself. But
I
you
did. The
understand
preliminary
you
exam
can
was
only
supposed to have
comprehend it.
witnesses.
This is not a preliminary examination, ma'am.
Oh, I thought that's what that was. I was just under the impression it was a
Refer for
preliminary.
competency, and I'm going to schedule this for a hearing on November 20th in person, so we can have these conversations in person and see if they go any
Well, I
different.
don't have any way to get there. I live very far away from where this is now.
Then I think when you get picked up and you're required to come here by police, then you'll have a way to
But
get here.
why would that be necessary? All I'm asking, I'm challenging jurisdiction, which I'm allowed to do without being retaliated against. You're retaliating against me because I'm challenging the jurisdiction of the court. And that's
is
a
not what's
violation of
going
my
on.
rights.
Okay, Ms. Doneski, you either need to be here, you need to participate in the competency, and you need to be here on November 20th, or you will
Well,
be
I'm going to be
arrested.
filing with the Court of Appeals on this
Go ahead,
and the
ma'am.
Court of Claims because this
Thank
is
you.
not okay.
All right. Bond is continued for now. Once you get the notice of your actual interview from the forensic department, if you don't participate, I'll issue a bench warrant.
And that wraps this heated pretrial. To summarize, Lindsay Janeski faces charges of assaulting, resisting, or obstructing a police officer. The hearing was dominated by disputes over filings, interruptions, and her demand to represent herself. Ultimately, the judge ordered a competency evaluation, a move that could stall the case until her mental fitness is confirmed. This isn't just about one defendant's stubbornness. It highlights the delicate balance between a defendant's constitutional rights and the courtroom's need for order. What do you think? Was the judge fair in pushing for a competency exam, or was Lindsay simply standing up for her rights? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.